Hi there, my name is Stephanie Stegan, and today I want to present to you our group project. It's done by Carrie Ward, myself, Stephanie Stegan, Katie McCombs-Williams, and Quentin Turner. We put together a PowerPoint today to tell you a little bit about law and ethics for our instructional leadership class. And what it contains is just some information that's very important for teachers to know about the laws that we really deal with kind of every day. I want to start off with religion and prayer and Bible reading in school. The First Amendment contains the Establishment Clause, which means that schools cannot aid or inhibit the religion. They have to have a neutral belief, a principle of neutrality, which means that school-sponsored prayer is illegal because, and Bible reading has to be strictly for secular purposes, because you can't just have one religion. You have to be able to, you have to be neutral to all of them. Private voluntary prayer by a student is legal as long as it doesn't interfere with anyone else. And schools, they cannot display any religious symbols, exhibits, or visual materials. That also goes with prayer. It also has to be voluntary with the students. A teacher cannot lead a group in prayer, cannot do, give the class in prayer, anything like that. Now, you have to have equal access. Schools can't allow one religious group to do one thing, to meet at the school before or after without allowing all religious groups or clubs. So if you have one club that is maybe a Christian club, you also, if someone comes to you and wants to do a Muslim club or any other kind of club, you have to be able to let them to do that. Now, the theory of evolution is up to the school systems to choose what's taught in the schools because it's scientific and based on evidence and not religion. And the Bible can be taught, but it has to be for a secular purpose. So it could be as a literature class, viewing it as literature, those kinds of things. It has to be secular. Teachers do have religious freedom. We can practice our religion, but we can't teach about it in our class. We can't, and it can't be distracted to the student, and it can't violate that neutrality, that Establishment Clause, the idea of neutrality. Now, freedom of expressions for students. They do have rights when they come into the school. They don't drop their rights when they walk in to the school. They can protest and do demonstrations, and they are considered forms of free expression. However, they have to be peaceful, and they can't violate the school rules, and they can't result in destruction of school property. They can't, if there's a policy or some kind of something that they can't do that on school grounds, and they can't. But otherwise, if they're not violating school rules, then they can do that. Schools can regulate the time, the place, and the manner that the students protest. So it can't be during a class time or anything like that unless the students choose to, and in that case they're breaking a rule. They can't engage in protest and block the corridors, and they can't prevent the free movement of the students that don't want to protest. And then for student newspapers, the faculty can be the editor, but the students have the final say. They have to follow responsible journalism. They can't just make up things. They can't be liable. They can't put other students in danger, those kinds of things. But basically the faculty sponsor has to be the editor and is basically there for editing purposes, not for content purposes. Moving on to search and seizure. Now, teachers, they don't need a warrant or probable cause to search a student, but they do need reasonable suspicion. They can't just, I think that this is what you have, and then start searching the student. They have to, and if there's an informant, it can't be anonymous. The informant has to give credible information, and the courts will likely support the search. Otherwise, it could be just thrown out and not counted for anything. Strip searches are not looked upon well. They need to be avoided except for in extreme circumstances involving the health and safety of the students. And of course, you wouldn't want to be the only person to do that. You would want to have a witness, those kinds of things. School officials are provided greater latitude when it comes to desks and lockers because they're the property of the students, of the school. They can be searched by school officials if, again, they meet that reasonable suspicion, and the student should be informed about the search before it takes place. Schools can search the students' cars that are parked on property, and again, reasonable suspicion has to be come from a credible source, and that they really think that they're going to find what they're looking for. Okay. And then searching students' phones or messages, that is not allowed. That is not allowed. And then for any search, the magnitude of the event, the extent of the intrusiveness, the nature of the evidence, and the background of the student, all of that has to be taken into account before you start searching. So that's really something. And again, something that we talked about, that is that when you're doing a search, you don't want to be the only person doing it. You most likely you'd want to have your admin there. If you are admin, you might want to have the teacher that's involved, that kind of thing for search and seizure. Moving on to children with disabilities, this is something that as teachers that everybody deals with, and it's the IDEA, the Individuals of Disability Education Act, and it guarantees that children with disabilities from age 3 to 21 the right to a free and appropriate public education. Schools and teachers providing the services, you know that when you sign off on that paper every year that you need to know exactly what services that child needs and you need to understand what they are. The school personnel needs to be aware of any liability challenges related to the student services. So we should know what's going on. Like we said, it all should be in the IEP, and when you sign off on that, you should know what's going on. The parents have the right to request testing, evaluations, and to help make decisions. And if they've got an IEP already and they feel like something needs to be changed, they have that right also to request a meeting and to request the changes to be made. Students have to receive the services in their least restrictive environment, meaning where they can learn the best. And that's usually done through evaluations and different things like that to determine that least restrictive environment. And schools may have to extend services past the school year, meaning some students that they feel like they will regress in their IEPs, they are extended summer school, like usually it's summer school, but extended year services. Now, due process is applied where if you are accused of something, or a student or a teacher is accused of something, then if you feel like your rights have been violated, it ensures the practice of fairness, a fair process, and fair procedures. Basically, it's all about fairness and to make sure that what is fair for everyone. Teachers and students are provided due process, and due process is designed to prohibit arbitrary and capricious action by school officials, so that people cannot just make up something and then you're in trouble for it. You get to go through this process to make sure, kind of like what our court system is, basically. Now, there's procedural due process and substantive due process, and both of these factors have to be coinciding to be able to go through due process. So procedural, is that it? It's a process. It's a set of procedures to be followed after any alleged infraction. They have the right, students and teachers have the right to be notified of the charges and a chance to be heard for their infractions. And it's created to prevent just random accusations against students and teachers. And then the substantive, they protect the students' rights regarding freedom of speech and assembly and religion, and they protect the students from random acts of school leadership, to take away their personal freedoms. So say a principal can't take away a student's rights unless that student is like hurting, if it's infringing upon another student, those rights can't be taken away. It kind of goes back to the student right to protest, unless that student is, hurting somebody or something like that. But the due process is there to help make sure that the fairness is there before a student or a teacher receives punishment. Liability in student records, FERPA, would be the Family Education Rights and Privacy Act. It guarantees the confidentiality of student records, and it's to protect the information so that students' information isn't just put out there without a parent consent. School districts, it's up to school districts usually to make policies on where these records are stored and how they're handled, who can handle them, those kinds of things. And who can make this information available to the parents, because you want the least amount of people with that information, with availability to that information. It has information about where they live, their families, their health issues, their grades, test results, disciplinary actions, their IEPs, those kinds of things. And permission can be granted by the parent to release information to be put into a school directory, which would basically just be phone number, address, email, those kinds of things. A few other specific things about records. Parents have the right to inspect the records. Non-custodial parents can have access to the student records. Other schools, when they switch schools, when a student switches schools, they have access to the records. Information can be released to the military for recruiting purposes whenever they get into high school. School personnel, they cannot participate in slander or libel or acts of malice regarding student records. You can't put how you feel about a student. If that student, never did their homework, or if they were disrespectful, or if they made you angry, you can't put that in their records. That's that you can't, you can't say anything slanderous or anything like that against. It's facts, it's information, it's data, basically. And when a student is 18 years old, they can inspect the records without the consent of parent. And when you go to college, a lot of times students, they have to sign something or whatever to make sure that parents get to see those records, because after they turn 18, parents really don't have access. They're not the first point of access anymore to those records. And finally, the Alabama Educator Code of Ethics is written so that teachers follow these laws and know these laws. And if they follow the Code of Ethics, they basically won't they'll know what to do. There are 9 standards of ethical practices for teachers: professional conduct, trustworthiness, unlawful acts, student-teacher relationships, alcohol, drug, and tobacco use, public funds and property, and remunerative conduct. Those are 9 standards to ensure that the teachers hold up the ethics and the beliefs of the profession. The document gives examples of practices, best practices, and unethical standards. And it also shows the way to report unethical practices, and that we are need to be accountable for those. If we see a colleague being unethical and in that behavior, we need to do that. We need to report that so that it retains the professionalism of our profession. Our resources were basically the Alabama Educator Code of Ethics, and then our School Law and Public Schools, a book that we read and did case studies from. I hope that this gave you a little bit of information about some of the laws that we need to remember in our classroom. Thank you.